let's go. So I'm really happy to welcome all of you here, and I want to stress out the fact that Mrs. Jaworski and Mrs. Camproux, who are presenting their study to you today, made a wonderful job and very inspiring job raising both analysis and proposals, and we're really happy to have them. But I also want to stress out that all the people that are here today are cooperating with us on a very regular basis. And this is really great to have such engaged teams to work all together. So I want to thank everyone for being here and with us today, but not only today, almost every day, working on this very important issue. So I'll try to be quick in my introduction because yeah, we have very important speakers today. But we ordered this study together with the Greens EFA cluster on ecological transition, which is a working group of the Green MEPs working on an ecological transition, because it seemed to us that when we look at the state of the environment, we see that the situation is still deteriorating on different dimensions. For instance, if we take the data from the European Environmental Agency, we still have 77% of habitat types and 60% of species protected under EU law, which have an unfavorable conservation status. And if we look at the criminal activity, then we see that the environmental crime sector is fast growing. It is already the fourth largest criminal activity in the world, growing at a rate between 5 and 7% per year, according to Interpol and the UN Environmental Programme estimate. And we have Eurojust with us today talking, we'll talk also about this statistics, but we also know, and we'll address that some of the environmental crimes, or at least damages to the environment, are still not covered by any law, and most often with law that have low sanctions. I'm sorry for my English accent. So this raises two questions. First, is the legal aspect of the Green Deal strong enough to face with the environmental emergency and to allow us to reach out the environmental goals that are now being adopted in the context of this Green Deal? The second question is more deep. Is our legal paradigm, the way we built our law in the EU, good or not, sufficient or not, to protect our planet, to protect humanity, to protect all of the living? And what it seems is that this legal context, the social contract that we have in the EU, has proven largely insufficient because of its anthropocentrism, of course. We don't manage to protect the ecosystems for the intrinsic value, but also because of its weaknesses. And that's what we will address today with this study that is very important to us because it addresses leads that are very important to dig into. And the researchers who made this study were quoting Mireille Delmas-Marty, who is a famous French lawyer, and she wrote books and she calls for the imagining force of the law. And this, with this appellation, we want to launch the presentation of this study to call on us to imagine new ways, a new social contract, which could be as well a natural contract. So I won't go into more details because the study will speak for itself, but just to give you a few information about what we could reach up to that point in the European Parliament. In October 2020, we called for the recognition of global natural commons and the rights, and last week again for the rights of the ecosystems to be protected. This is quite important. It's a move from the European Parliament towards the rights of nature. And we will keep on pushing in that direction, although it raises many questions, among which some we will address today, that still need to be precise and to develop a European answer to the questions behind this. Also, the European Parliament called in January officially for the recognition and the support of the Commission and the Member States to the recognition of ecocide at the International Criminal Court. And last week, again, we also called for the inscription of ecocide in EU law, which would mean that we could recognize ecocide without waiting for an agreement at the ICC level. However, we wanted to go fast, and we'll dig into it with Jojo Mehta. So before giving them the floor, just a presentation of our speakers of today. So we have, of course, our two researchers, Véronique Jaworski and Marie-Pierre Camproux, and they will tell you a bit more what their work is about and what they propose. We also welcome Jelena Smirnova from Eurojust, and she will talk to us about environmental crimes in the EU, which, as I said, is really important, and I thank her a lot for a proposal to join us today. We also welcome Jojo Mehta, who is the chair and international director of the Stop Ecocide Foundation, working at international level and with international experts towards the recognition of ecocide as an international crime. And I'm very happy as well to welcome Emmanuel Daoud, who is a French lawyer specialized in criminal law, but who is also one of the lawyers, maybe the main lawyer of the case of the century, l'affaire du siècle, which is the successful climate litigation case in France. And he knows a lot about the cases, the legal cases that we bring in France and more than in France to protect the environment. So I'm really happy to have him on board. We also have two people who are working on concrete changes in the European legislation. And I'm very happy to have here again, and is always with us, Peter Tsonka, head of the unit at the DG Justice of the European Commission, who is working especially on environmental criminal law in the EU. And you might know that we will have, and it's fortunate, a revision of the environmental directive on the protection of the environment for criminal law, normally by the end of the year. You will be able to tell us more also about the agenda. And Mrs. Isabelle Pérignon, whom we're really glad to welcome today, who is working in the cabinet of the Commissioner Reynders and the Commissioner for Justice, who has brought already several proposals to reinforce this legal aspect of the Green Deal for corporate governance, through this revision of the directive on the protection of the environment for penal law, and who might be in the right place also to give us insight about what's expected and how we can maybe integrate the proposals from the study that we will listen to right now, because I'm giving now, and it's time, the floor directly to Mrs. Camproux and Mrs. Jaworski. It's to you. Thanks a lot to both of you.
Yeah, donc je vais partager mon...
I'm just going to share my screen with you all. Sorry, how do I share my screen but still see you at the same time? Because I can't see you. I don't think that's possible. Unfortunately, it's one or the other. Would you prefer to see me or my presentation? For us, we can see both at the same time. Okay, so you can see me now. Oh, great. Okay, I don't need to see you all, so that's fine. Okay, but we can't see your screen, your presentation. But when you share your presentation, we'll be able to see you at the same time. Okay, you're just going to have to, I'll have to use my imagination then to see you. Okay, so can you see me and my presentation, but I can't see you, that's it? Okay. I'll try like this then. Sorry about that. First of all, I'd like to thank Marie-Toussaint for allowing us to present our scientific work here today. Just quickly, because we don't have very much time, I'm going to present to you what we can foresee, legally speaking, when it comes to natural commons. So what is a natural common? Why do we need to foresee it, and how? Envisage it, rather. Then I'm going to speak about the possibility of civil responsibility when it comes to environmental damage, because in France, there has been a trial for environmental damages and reparations. And so here we want to look at civil responsibility at a European level, how we can translate it to that level. So when it comes to natural commons, how can we legally punish environmental damage? So first of all, natural commons, I've given you this table. It's an inseparable whole, which is composed of a natural object, so a planet, a forest, the air, or a species, for example, and of a community or commoners, the commons. And this is composed of the living world. So this can be human and non-human at the same time. So the natural commons is all of these components. It's a composite unit, and it's also a system that is made up of the relationships and the interdependence between the human and non-human living world and the community that we live in, as well as the ecosystems that surround us. So it is an inseparable whole, and it is this fabric of interdependent relationships. It's functional between non-human and human species. So this is a theory that is working on the environmental transition of our society, and it encourages a change in the human nature relationship. And so it's going from this vision where mankind dominates nature to a vision where mankind isn't just a member of society or a human species, but is also part of a community with a common destiny and is part of an ecosystem on a planet that they are dependent on. So this is looking at a limited common world, which is common to humans and non-humans, which goes beyond a purely utilitarian vision or individualistic vision of nature. So when we speak about the commons, we talk about common objects, something that is unified, something that we experience together in a complex world. So we're not heading towards simplicity here. The world is a very complex reality. So this theory is encouraging a legal paradigm shift, going from a legal system that is looking at this dichotomy between subjects and objects of law. And this law is opposing two interests, so humans versus everything else, and non-human subjects. And so it's moving from this vision to a vision that is more about relationships and solidarity. So we're not looking at property or legal persons. We're not looking at subjects here. We are really putting forward this idea of the commons. So what are the legal consequences of the natural commons? So the objective of this theory is to maintain and restore natural commons and maintain the relationships between elements of this intracommunitary system. And so we are looking above all at sustainability and resilience of this systemic entity. We are looking at a dynamic system here. So this recognition of natural commons needs to be legally recognized. So this means protecting the use and access of these natural commons by a community. It's a common use, so it is not exclusive or individual. And this object is not appropriated. So conservation and sustainability of this natural object cannot be appropriated. So this prohibits appropriation or the destruction of objects and allows for the survival of human and non-human life. So what we can apply here is the legal system of natural commons, because with natural commons, there's this idea of non-appropriation of natural objects. So there's the common use of objects by all, and preserving this natural object that is linked to this non-exclusive use. So the consequences of this legal system of natural commons can be protected and defended by the recognition of a common interest. This is an interest that groups the interest of the object as well as the users and all the relationships therein. This is a common interest, and it is a common interest between human and non-human life. We can see this interest. It can be defended, or rather protected. And as I was saying earlier, in France, we do have this reparations movement for environmental damage, and that can be seen as the first example of this kind of legal system. I'm now going to look at reparations of environmental damage and what's going on in France. So there was a new law from the 8th of August 2016 in France, which updates the laws, and it represents a legal paradigm shift. And so in its civil code, it states that environmental damage, which consists of the considerable harm of elements or functions of an ecosystem to the benefit, to the collective benefit of mankind. Here we aren't looking physically at harm caused to a human being or property, but rather we are looking at harm caused to non-human interests, damage caused to ecosystems, or harm which has harmed human interest, but only in a collective dimension. So here, these are collective benefits. This environmental damage corresponds to the harm of natural common interest. And so these interests are not exclusive, but rather inclusive for human and non-human life. This environmental damage, if it cannot be repaired, then we need to look at civil responsibility and reparations. Of course, there are many other aspects that should be taken into consideration, but first of all, the perpetrators of the action there will often be more than one. So they will need to be identified, and they will be coexisting with the system. And they can be human or non-human. So the second element is the reparation must be about re-establishing the functioning of the natural common and ensuring the health and well-being of human and non-human communities that are attached to it. So re-establishing this balance and returning to the initial trajectory of the ecosystem. Now, I'm not too sure where I am in terms of my 10-minute time slot. I haven't been keeping track of the time, says the speaker. You've been speaking for about 10 minutes. Okay, well, what I wanted to say next was that with this action, with this process about reparations for environmental damage, we're not only looking at, we're not focusing here on humans and property, but this is rather about harm caused to the environment. So we need to be able to establish civil responsibility or civil liability when it comes to environmental damage. I had highlighted various different elements that should be worked on for the directive that focus more on civil liability. But we can discuss this later. Or maybe you could try and explain in just 2 minutes. If we look at this environmental responsibility directive, it talks about having administrative police. That's what we've had in France. So it's up to the state to decide whether to act or not when it comes to the damages caused. So instead of resorting to the state, you can go to a more direct level. So the perpetrators of the damages caused, you can go directly to them. Then we're looking at the definition of environmental damage. So this could be damage to the earth itself, or maybe even to the air, human health. We want to also include species and non-protected habitats, because for the moment we talk a lot about protected biodiversity. And then when it comes to the seriousness of the case, that's also up for discussion. When we look at the responsibility of the action, we need to think about all people who could be involved. I was saying earlier that this will be about a group of perpetrators. So this plurality shouldn't engender a non-cumulative action, because when we talk about reparations of environmental damage, we need to encourage measures that focus more on prevention or repairing environmental damage. And we really encourage reparations in kind. And if that is not possible, then of course we'll look at indemnities and indemnization. So perhaps it would be donating money to a fund that doesn't currently exist, but this is all just up for discussion. Now, when it comes to civil responsibility, civil liability, in terms of this, we can encourage the idea of including the burden of proof. So rather than having to prove the existence of damage, we thought we could focus more on this burden of proof that is about facilitating life. Now, when it comes to defense and protection, we want to look at environmental damage. And there, as I was saying earlier, there can be several perpetrators. And we need to look at how to coordinate all of this and see what the obligation to the debt is. So that was it, just very quickly. Thank you very much. Véronique.
Alors, moi, je vais en fait vous présenter la partie pénale.
I'm now going to present the criminal part of our study. So we have seen that with this acceleration of phenomena such as degradation, the environmental challenges have increased. And now we are in a situation of an environmental crisis. So the current challenge is this fight against impunity when faced with environmental crime, which can be done at a national as well as a cross-border level. This is increasing, and today it is jeopardizing the safety of the planet, and as a result of this, the very survival of humankind. So we need a legal paradigm shift so that we can put forward a coherent model where the environmental criminal code can be reinvented. So I'm going to explain in two main stages here. Firstly, we need to look at the question, the raison d'etre of criminal code. This is called the ratio legis, and we need to strengthen it faced with the environmental crisis. So more concretely speaking, what are the challenges that we need to tackle? What do we need to safeguard? And what are the essential social values that the criminal code needs to protect? So first of all, we're looking at environmental law. And we need to get out of this idea of anthropocentrism, which is what the majority of our legal texts and political discourse is focused on. They don't focus on environment per se, but rather on humans. So we need to have a more ecocentric vision here, which is based on systems of relationships and interrelationships, which is more turned towards a global and common objective, which is quite simply the viability of the planet and the balance of our biosphere. So we need to be aware that fighting against environmental damage is, of course, fighting to protect humanity, both present and in the future, but also to protect the current and future balance of the planet and everything that composes it. So this is both human and the human and non-human living world. So the objective is to put in place a new system of values, which is based on a systemic and universal approach. And from there, we will have new legal notions to represent them. So speaking of these legal notions, we could say that the environment needs to be preserved, and it is the common heritage of living beings. So it is made up of everything that makes up the natural commons. It has an interdependent link, and it assures the balance of the biosphere and the sustainability of human and non-living, human and non-human life, rather.
Elle a alors des répercussions en termes de sûreté.
So all of this has consequences on the safety of the planet, which is a new and emerging common value at an international level. And through this, we can aim for the sustainability of the planet Earth, and with that, the future of humanity. So the advantage of this is the holistic aspect, which looks at the balance of the biosphere, all ecosystems in terms of how they are composed, and as well as their structures and how they function. So safeguarding the planet is about constituting the ratio legis, or rather the raison d'etre of these new these new crimes, rather, that come from this legal paradigm shift. So these new essential values will allow for us to create a new criminal code structure, which will take on new relevance when it comes to the challenges that we currently face. Using sanctions or punishments due to the climate crisis is vital for the humanity as well as the planet. So we need a new criminal code, rather than having the current legal system, which has quite a limited scope. So we need to rejig our criminal system, and we need to fight against this mass damage, which has effects for the sustainability of the planet. We cannot just put up with having a sectoral approach, but rather we need a more systemic approach. Now, this systemic approach doesn't currently exist in our legal texts, so we need to put forward more comprehensive crimes which severely punish behavior that impacts the safety of the planet, so that we can guarantee the rights of future generations. So we need to look at the irreversibility of certain behaviors. Now, these new crimes that threaten the environment could be used in a process that will be repressed in two different times. So either beforehand, so here we could say you are putting something at risk there might be environmental disasters. So here there will be this will be a specific type of crime where particularly dangerous behavior will be incriminated. And so they will be punished for certain uses, certain behaviors. And we could say that maybe later on in time, this eventually will become irreversible. And so having this formal crime could be used as an obstacle for them to continue their behavior and carry out more serious crimes. So then the second option is if the preventive measures haven't worked, then you would here move on to the crime of ecocide. This is the most serious crime that can be committed against the environment because it damages the safety of the planet. So ecocide is the severe and extensive damage of one or several ecosystems, or even of their destruction, which can have consequences on several generations. Ecocide is a very worrying reality today because a number of the environmental pollution and degradation that we are seeing by our economic activity, for example, transnational companies who are carrying out activities in developing countries, could be qualified as ecocide. If these behaviors are not rapidly punished at an international or national level, then these companies are going to continue their activities, and this will cause mass damage at a planetary level. So the climate crisis urgently requires this recognition of the crime of ecocide, because it threatens the common heritage of living beings. So in practice, we are looking at different species that are not governed by current laws, by the current criminal code. And so it would be up to lawmakers and legal experts to tackle these problems, both in terms of preventative measures and after. Because the main problem at the moment is impunity. There are criminal groups that we are calling eco-mafias who are carrying out illegal activities. But also there are companies who are carrying out their work completely legally, but their actions are damaging the environment. So I think this impunity is becoming increasingly unacceptable. It is threatening the very existence of mankind and the sustainability of the planet, and we are all linked together. So thank you very much for listening, and we are here to answer any questions that you might have. Thank you, Véronique and Marie-Pierre. I hope that everything that you have brought up has triggered a lot of questions. I can already see people have been writing some. I think you've already responded to some of them, which is great. I'm receiving messages to say that your presentation is very clear, and I hope that we can use it as a basis to continue our work. I'm now going to turn to Ms. Smirnova from Eurojust, who's going to talk about crimes and impunity. You have worked on the notion of environmental crime at Eurojust. I can see you are connected, so I will give you the floor for 5 minutes.
Thank you very much. I will start my presentation, just 2 slides. I'm extremely grateful for the opportunity to participate.
Wait, since you haven't turned your camera on, I think that you need to turn it on for us to see your slides.
Oh, excuse me, please.
No, it's okay.
Is my option to start video deactivated? I cannot manage it by myself. I'm sorry. Cannot start.
Can you help us, please?
Yes, I did it now, but I think your camera doesn't work maybe because it's so loud.
It's allowed.
But if you can't share your screen, I can quickly open your PowerPoint on my computer and share it.
That would be helpful. Thank you.
Okay,
Because
so,
I keep receiving messages. I cannot start my video.
okay, so just 1 second.
Thank you.
Merci, Philippe.
Can you see?
Allez, c'est bon. Go ahead.
Okay.
Thank you again. It is very fascinating to be among the first who hears about this study and learns about these findings and recommendations. It's really mind-blowing. I represent here Eurojust, and it is EU agency with rather unique mandate and perspective, I would say, because we are mandated to facilitate cooperation between judicial authorities of member states on serious cross-border crimes, including environmental crimes. And this allows us to gather a kind of pan-European overview of what is happening in criminal investigations and prosecutions in the EU on cross-border environmental crimes, how often such crimes are prosecuted, what are the types of environmental crime most frequently prosecuted in Europe, what are the challenges in prosecuting and bringing to justice perpetrators of those crimes, and what are the best practices when it comes to the international cooperation, particularly on such criminal cases. And from our Eurojust casework, we do clearly see that the current approach to protecting environmental crime through environment through criminal law has its limits. Let's put it this way. And the basis for this statement for us is the report which we recently published when we looked back at a 5-year period of our casework on environmental crime. On my slide, you see the points highlighting which exactly aspects this report covered. But of course, I will not bring up all of them here, but I will highlight just 2 findings from this casework analysis. I have put on this slide the link to the report. So for those of you who are interested, it's available online. And I really encourage and welcome you to take a look at this report. But now I would like if you could please move to the next slide. And the first highlight, which I would like to bring up, is the following. We have just heard that indeed this crime, environmental crime, now is estimated by some key actors, key stakeholders like EU Environment Programme and Interpol as the 4th largest criminal activity in the world if we look at the amount of the illegally generated profits. What we have found in our casework, that this type of crime constitutes less than 1% of the total Eurojust casework, less than 1%, which is of course absolutely insufficient and totally inadequate. We are talking about cases brought to EU level for coordination among member states and some non-EU countries. On my slide, you see which countries are the most active in referring cases to Eurojust. I have to say that we work on the basis of referrals of cases to Eurojust as a starting point by competent authorities investigating and prosecuting those cases. Mainly, even not all member states refer such cases to Eurojust in the period at which we looked at. You see that approximately less than 10 cases per year have been dealt with between 2014 and 2018. You see an increase in 2018. This happened in the context of Dieselgate, when, as you may remember, the fraud in the car industry was detected and started being investigated. The second highlight, which I would like to bring up, is that we find from our casework that there is definitely a lack of recognition of environmental crime as a serious crime. To bring environmental crimes to justice, prosecutors have to rely on the so-called associated crimes, the crimes which are committed together with environmental crimes. The majority of environmental crime cases do involve other crimes, and the top types would be organized crime, fraud, document forgery, money laundering. And to ensure significant criminal sanctions in relation to the cases on environmental crime, and not only for that, but even to open up the possibility for international cooperation on the cases, the prosecutors have to rely on these crimes rather than on environmental crime. This is because environmental crimes are not defined in such a clear and harmonized manner across EU national jurisdictions that it would be possible to rely on them. And they are not punishable by such equally significant sanctions that they would be the basis for the international cooperation on the cases. So this proposal to introduce these two serious crimes, ecocide and endangering the safety of the planet, yeah, they of course are very innovative and daring from my point of view, but from the practitioner's point of view, I do think that it is indeed the time to rethink and to reform the system of concepts in environmental criminal law at the EU, at national level, because the current approach indeed seems to be clearly lacking efficiency. And if you wish to rely on empirical evidence from the Eurojust casework to somehow promote and advertise your findings, as I said, Eurojust report is published and the data is there. I will stop here. I hope you will find the report and the data in the report informative and useful, and congratulations for your excellent work and the outcome of the study. Thank you.
Well, congratulations to you as well. And thanks to Felipe Calderon for sending the link to the report, which is in the chat. If you want to have the entire report, you can find it here. I turn directly to Jojo Mehta, please. Also 5 minutes, it was perfect timing.
Thank you. And thank you for the opportunity to take part in this discussion. Thank you also to Marie-Pierre Camproux and Véronique Jaworski for this important study highlighting the urgent need for the EU to step into new legal territory in order to adequately confront the global ecological crisis in which we find ourselves. The good news is that this territory is becoming rather well prepared to be stepped into. Our foundation, the Stop Ecocide Foundation, operates at a very interesting nexus around a highly specific strategic legal intervention, which is to say the criminalization of ecocide. We see this as very precise and strategic in that it's actionable within the current system and can act as both a much needed safety parameter, a sort of guardrail, if you like, for corporate practice, and also a kind of bridging piece towards an overall healthier legal model for people and planet, such as that described by the authors of this new study. We're closely involved in legal developments around ecocide, in the growing political traction of this initiative, and also with the public narrative around it. And in all three areas, EU member states figure strongly. So on the legal side, our foundation was asked last summer by parliamentarians from the ruling parties in Sweden whether we could convene or commission a clear and credible draft proposal for ecocide as an international crime, which could be considered by interested states. And this real-world political interest enabled us to convene a panel of 12 really top-level international and criminal lawyers from around the globe, led by world-renowned barrister Professor Philippe Sands, QC, and Senegalese jurist Dior Falso. The work of the panel is coming to a conclusion this month, and it will be launched with a press conference on the 22nd of June. And this work will also be complemented at the EU level by another weighty project being undertaken by the European Law Institute, a project led by Judge Fausto Pocar and lawyer Robert Bray, which will develop further the work of the panel convened by our foundation and working in particular on the EU context. So the work of delineating this new legal territory indicated by this new study is already in progress. There is also a growing interest from states in criminalizing ecocide. Initially, as you may know, from small island developing states, Vanuatu and the Maldives. These low-lying island nations have an existential incentive to address acts which exacerbate their already precarious position with regard to the effects of climate change. France, of course, is already some way down the road in attempting to address new environmental offences, although I hesitate to describe the legislation currently progressing there as ecocide, since it is not at the level described in the study we're discussing today. President Macron has clearly expressed support for developments at the international level as well. And France's due diligence laws also point in a direction which it seems, and we certainly hope, is also being taken more seriously at the EU level in the context of the liability of companies for environmental damage. And this is clearly important with respect to encouraging an attitude of avoiding genuine hazards. An approach is grounded in the possibility of taking account of real potential physical harm, rather than simply trying to mitigate risks, which simply assumes that current activities are okay if they are somehow offset or tempered.
Jojo, just sorry to interrupt. Can you speak it just a little bit slower for our interpreters? Thank you.
I'm sorry. So it's important to highlight Belgium in this conversation. The government there has included addressing ecocide legally and diplomatically in its pledges for this 4-year session, and also in its most recent statement to the International Criminal Court. Finland, Spain, and Luxembourg have also expressed interest in various ways. Spain's Foreign Affairs Committee has strongly urged the government to examine legislating for ecocide, and Luxembourg has stated that it is ready to support when the time is right. Indeed, it is EU countries which are globally at the forefront of initiatives supporting stronger environmental stewardship and protection. If we look, for example, at the Leaders' Pledge initiated in the UK last year, or at the legally binding treaty on transnational corporations, which is being developed at the United Nations, we see that EU member states feature prominently. The recent reports adopted just last month in the European Parliament, which Marie briefly touched on earlier, and with strong majorities too, also show that there is a real appetite for addressing the better enforcement of environmental law, as well as the harmonizing and evolving of that law. In the public sphere, we also see a strong growth of interest in many sectors, and a very recent example is a new Swedish initiative which is gathering support from business leaders for a law of ecocide. Their first webinar went online this Monday and had already been viewed over 10,000 times after 48 hours. So again, this is a very encouraging gauge of appetite in the corporate sector. And of course, grassroots public pressure is key in all of this, as the French Citizens' Climate Assembly clearly showed when it supported ecocide law almost unanimously. Courtesy of grassroots climate mobilizations in the last 2 years, the information coming from climate and environmental scientists already for some years now, for many years, has now at last become a major conversation in the media, in politics, and also in people's homes as a living room conversation. And the strengthening of environmental criminal law to include ecocide is rapidly becoming a part of that conversation. We trust that the EU will not miss its moment to lead in addressing that conversation. And I'll just finish by saying that criminalizing ecocide at the international level, be that at the ICC, be that in the EU, will, we believe, have a strongly strengthening and empowering effect on the enforcement and development of environmental law in general and environmental regulation. So we see this as an incredibly important bridging piece and development in this whole conversation. Thank you.
Merci beaucoup Jojo, et merci pour tout le travail qui est effectué par la
Thank you for all the work that has been carried out by the Ecocide Foundation. Thank you. We will engage in this battle. It's important to have your point of view when it comes to Eurojust and also when it comes to the action to have one proposal. And now Mr. Daoud, who is a practitioner, so that he can talk to us about the evolution of law, is defending every day the nature rights. You have the floor for 5 minutes. Thank you. Good morning. I will ask you to take the time so that I don't abuse of my intervention. Just 2 remarks. The first one, I will surprise some of you when I speak about the debate, and I will tell you why, and then I will tell you what's happening in France without touching the European level, because I'm more specialized in France, and 5 minutes I don't have time. Why I am king imbecile, he says, and I exercise the function of the criminal practitioner for 33 years, and I can tell you that compared to the past, the awareness that we have at present when it comes to the protecting environment and climate in France, in Europe, and in the world has nothing in common when it comes to the professional practices of the prosecutors who are prosecuting crimes linked to environment. There is a new awareness when it comes to the climate emergency, and some of you know this already, the chamber of the Cassation Court, when it comes to the initiative of the prosecutor, which is the major prosecutor in France, launched a training on the criminalization linked to the right of the nature and the damage, environmental damage. And when we start this exercise in France for both practitioners and prosecutors, that means that there is a real awareness. Second remark, you have seen the transposition in the French law regarding the European law from December to create a public interest jurisdiction for environment. What does it mean for no expert? It means that companies that are object of prosecution can arrange an agreement with the prosecutor to recognize the materiality of the damage that have lodged, and then find an agreement to redress the damage, and then to start a monitoring program to monitor if this company in 3, 4, 5 years is improving its behavior when it comes to environmental protection. So we do not know at present how this will be implemented. Everything depends on the environment minister. There are many criticisms at present when it comes to this exercise, because it means that the company won't be prosecuted. And so all questions regarding of recidive when you commit again a crime, well, this won't be prosecuted in France. And when it comes to the corruption, so well, these companies won't have any sanction. And this, you know, some people will say, well, you just pay and you can continue to pollute. So for practitioners, this is anyway a step forward compared to the past. And some other step forward, and we will see how we will implement this. 4th of May 2021, maybe you know, some of you know about what happened in France, the adoption in France of the decree for the reinforcement of resilience to combat environmental damage. And this is the translation of the engagement that has been enshrined by the Citizen Convention, and the legislator in first reading, and this will be submitted to the Senate in June, he considered to, in line with the conclusion to Madame Jaworski and Madame Camproux, that the administrative way was not enough anymore, so that you need to take into consideration the damage, the environmental damage, and to take this into consideration, you need a criminal repression, and this has a symbolic meaning, if you want. And so we have 3 crimes. The first one is to endangerment of the environment, because which is based on a minimum number of acts. And this crime of endangerment will be considered by the prosecutors only if it translates into a serious crime that can put into danger in 10 years. I'm not an engineer, but I don't know how we can evaluate a risk in 10 years time when the risk is not there. But anyway, it's been launched, and this would be the first offense. And then we have a second debate, the crime of ecocide. The crime of ecocide means that you are prosecuted in a correctional court, and this means that it's not the same crime, because we are talking of less than 10 years for ecocide. And an association ever said, as proposed, 15 years of prosecution for ecocide damage. So this ecocide crime has been created. We will wait for the Senate to approve it with aggravated circumstances if it's committed intentionally. So if there is the intention to commit the damage, then there is is this enough? We will see the amendments to improve the amendments in the Senate. We will see what text will be adopted by the Senate. But I think that it's time that with this emergency that we have, with the emergency of the case of the century and the emergency stemming from the signature of the convention, maybe Mr. Macron, we will act because, well, it's time to consider the environment as a major element in the next election. Maybe I can be in a happy, stupid, as I said at the beginning. Anyway, but to respect my timing, I would like to insist on a very particular point, because we are dissociate sometimes criminal and civil law, because sometimes companies have to respond to the vigilance law, and this law establish a mapping of the risk. So you need to prevent every damage for the environment and human law. And in the transposition that the European Parliament with the control of Marie, of course, that asked in June to present a directive for vigilance that will be transposed in the EU. This law will go well beyond the French law. This is what the party wants, and the protection of climate will be a major objective which will be imposed to all companies in the EU. I think that this will be a dream, but I think that this dream will become true very soon. And if we think that in France or in other countries we will get a repressive law and also a collaborative law as the vigilant law, so that companies are forced to answer to the requests of different parties. I think that there is a represented here of association Les Amis de la Terre, who's working very much when it comes to the law in France. There is a virtual circle that is getting established, so let's keep the pressure, and the practitioner see that at the moment we have instruments that allow us to activate also the mediatic elements, because this is what is bad for companies. Thank you for your attention. Thank you, Emmanuel. Many things, and maybe we could think about synergical model to have a legal paradigm shift. And now, Mr. Tsonka and DG Justice of the European Commission to defend for the directive. I think that Isabelle Pérignon will take it. And
Bonheur.
Donc, je vais commencer et je passerai la parole à Peter Csonka, que vous connaissez bien. Donc, merci beaucoup, Madame la députée, pour votre invitation sur ce sujet qui me tient particulièrement à cœur. Donc, je suis vraiment ravie d'être avec vous cet après-midi. C'est une priorité vraiment pour la Commission.
It's a pleasure to be here with you today, and it is a priority for the Commission. We've seen this from the beginning. President Ursula von der Leyen, one of her first political acts, really at the very beginning of one of her first meetings in December 2019, when she first began her mandate, she adopted the Green Deal and all the measures that it includes. And so within this framework here, we have got a huge number of commissioners who are very active in terms of promoting and developing environmental law. So we really wanted to carry out actions in this sector. And I was very interested in the presentation that we heard earlier. We are all talking now about the climate crisis and this fight against cross-border environmental damage, because that's a real challenge for us. And it's very high on our agenda. So thank you, Véronique Jaworski and Marie-Pierre Camproux for your study. I'm just going to say a few words because Mr. Daoud has already spoken about this law of vigilance that we are preparing at a European level. We can confirm that this is a major topic that Commissioner Didier Reynders is working on. We are hoping that it will be adopted this autumn. It is a legislative proposal that is being supported by several commissioners, including French Commissioner Mr. Thierry Breton. I'm now going to focus my presentation on the topic at hand. So how Commissioner Reynders is being active in fighting against crime, environmental crimes. So I would like to present to you what we want to do, what we want to adopt this year, and by the end of this year. So we're going to look at the directive and environmental crime. This is a directive I know that you all know. It's 13 years old. It dates from 2008. When we had the first discussions with Commissioner Reynders about this directive, first we wanted to really analyze and evaluate what has been going on since 2008. And this is where we realized, and I'd like to echo what was said earlier today by Eurojust. So in practice, we have very little research. We can see that Eurojust has developed a lot, but I think you said it was less than 1%. So we had an instrument that existed, but in practice, it wasn't used enough. The sanctions were insufficient. And so we really needed a reform. So that's why we announced in this year's work program a reform of this directive. Mr. Tsonka will explain to you that we organize a public consultation with, we're preparing an impact report that we'll publish in September. And we really want to publish this all by the end of the year. So what do we want to make sure of? Firstly, clarifications. We need to clarify the scope of application of this directive. We want to specify legal definitions, clarify them. Ms. Jaworski mentioned earlier about what they actually currently have in France. But when we look at this at an EU level and the 27 member states, we can see that the situations are very different in different countries. The definitions vary hugely. So we need to look at what we can and if we can include other regions, such as, for example, or rather different crimes. So forest, deforestation rather. We are looking at the destruction of plant species that live in the woods. That's what we're currently looking at the moment. The second point that we would like to cover in the directive is to look at what types of crimes or infractions. Here we need to be a little more specific and cover all the different types of crimes. As has already been mentioned, we know that these cross-border crimes, we've spoken about eco-mafias were mentioned earlier. but we need to be very careful that this can be a source of organized crime. So once we know that it is criminal organizations behind these offences, we need to see what we can do there. The third point regarding this review is providing additional audits to Eurojust for their coordination actions, and also to Europol, OLAF, and the other existing networks when it comes to organised crime. Fourthly, we would like to harmonise the instruments, the tools that will allow us to carry out inquiries so that we can do them more effectively, and above all, tools that can help us when we are dealing with a cross-border crime. This is a trend that we have observed over the last 13 years. So those are really the main points that we are working on today. So it was very interesting for us to look at your study, because we're still very much so in the discussion phase of our work. So we are going to announce a reform of the directive, but we want to base ourselves on works and existing studies that have been carried out by associations and NGOs. We are also taking into account the report carried out by the jury committee on corporate responsibility for environmental crimes. So those are all the different areas that we are working on at the moment. And what we are heading towards here really is to really strengthen the fight against environmental crimes and environmental damage. For us, this is one of the main political issues. I have also taken note of your appeal to include ecocide and the concept of ecocide. We are thinking about, at this point, we would prefer to concentrate specifically on what can be done most quickly with this directive, so the directive that dates from 2008. But I have noted the works that you have done, and I would be really happy to stay in touch because I have a lot more questions for you, and I've run out of time, my speaking time, so thank you. Thank you. We also will always leave the door open to you, you know, even if it isn't about the directive. I think it's important to continue these discussions. We have heard a lot about the crime of ecocide, and also the civil as well as the criminal aspects of environmental damage. I'm sure we will have lots of other discussions about the directive. But first we need to overcome administrative barriers, deal with the situation of ecosystems and how we interact with them. We need to look at this at a European level, not just a French level. We need to look at interests as well that are shared between the human and non-human living world. So we don't have very much time left, but thank you very much, everyone, for all the information. Thank you for being here today so that we could have these exchanges. I think that this is really valuable for every one of us here today, and also for the audience. There are probably legal experts, professors, people from organizations, who are all interested in this topic, and we would all be very interested in staying in touch with one another. So now I can see we've got some questions in the Q&A, but we're nearly at the end of this conference, but it's been a real pleasure to have you all here today to talk about this subject. So I'll give the floor to our final speaker, Mr. Peter Tsonka. Thank you, everyone, and thank you for inviting me here today. I'm also very pleased to be here with you and to be able to take part in this extremely interesting and enriching conversation. This follows on from a dialogue that we've been carrying out with you for a while now, and it has been part of our discussions on reviewing the 2008 directive, which Isabelle has already given us some very clear explanations of. I don't really have very much to add to what she has said, other than for the sake of linguistic diversity, I might switch to English so that you can listen to the interpretation and you can react in the moment to what I heard from Professors Camproux and Jaworski on the study of the case of the century.
To switch to English, the first reaction I would say that the current directive that we have of 2008 already covers endangerment crimes. If you look at the directive, Article 3, paragraph A, B, D, and E of this directive already contain endangerment crimes. Now, this is a directive. Indeed, member states had to transpose that directive into domestic legislation. We checked that legislation. We never brought actually a proper infringement case. We found that all member states were compliant and that they have introduced these offenses. There are 9 categories described in that directive properly. So all of our member states have environmental crimes in their criminal codes, which in my view is a positive fact. If there is one, as a result of this directive, it's that there is a common level playing field, at least in terms of criminalization in Europe. But I fully agree that this doesn't mean that the offenses described in this directive or in national law, for that matter, are actually investigated and prosecuted. I think Eurojust casework fully illustrates the problem. We have the offenses in member states' legislation, but we don't have actually effective investigations, prosecutions, for various reasons. Let me go through the reasons. One, indeed, the offenses which we have in the directive are related all to a breach of administrative law. So there is a very close link between criminal law, criminalization, and the breach of environmental legislation, European environmental legislation, directives, regulations, decisions, which are listed over 100 in the 2 annexes to the directive. And this list is, by the way, not updated since 2008. So there is a link, and that link is not always obvious for national investigators and prosecutors. So there is a lack of clarity in the incrimination, in the way, in the method we criminalize environmental crime. We could, of course, change that method and move to an autonomous concept of environmental crime in which we criminalize the danger, the behavior, without waiting for the damage to the environment or the damage to human beings or to animals. But as I said, this is already included in the directive, and it has been transposed into domestic legislation. So this is not what is missing. We could also go as far as having a completely autonomous definition of environmental crime, which means there is no link whatsoever with administrative law, and it's a description of something which may be dangerous, but without having a link with the breach of a regulation and therefore breach of a permit, of an administrative authorization, which is usually the case. There is a breach of this administrative violation before we go to a criminal investigation. For example, all pollution cases relate to a breach of the pollution levels which are authorized in the permit of the ministry or of the municipality, etc. So it is the first issue that we need to discuss, exactly what is the method of criminalization that we want to employ, and how far can we go with that. We have checked with the member states. It is very unlikely that national authorities will accept a completely autonomous environmental crime offense. Endangerment, yes, but the likelihood that damage will occur has to be real and concrete and immediate. So there I join what Maitre Daoud just said. It is not easy to define environmental crime. The intentions are often good, but when it comes to substantive criminal law, one has to be precise because there's a requirement of being specific and otherwise the activity should not be criminalized. The second point I wanted to say is that sanctions are definitely missing in this directive. At that time, this directive was adopted on a different legal basis, environmental law. We could not harmonize sanction levels and types. So there's a jurisprudence of the Court of Justice. Now, what we will probably propose is to introduce minimum maximum sanctions, which means that we will achieve a minimum harmonization of the sanctions which are applicable in the member states without actually setting very strict terms for the legislator or for the application of this sanctions. So this is what we do normally in European Union criminal law. Of course, we can also look at accessory sanctions such as confiscation, so deprivation of the proceeds of crime from the enterprise which has saved money, which did not invest in recycling and purifying air or water which is released into the environment. So there, I think there is indeed a nouvelle piste, something we have to explore, including the reparation of the environment, an obligation on the legal person to reinstate the environment. A third possibility is indeed to introduce some obligations in a directive that would enhance the enforcement chain. This is a term that we are using nowadays in the preparation of the impact assessment, which means the chain of authorities from inspection to the court that need to be linked one with the other, and they all need to do their work. So the inspectorate needs to report, police need to investigate, and prosecution has to have investigation that Isabelle described. For example, those applicable to serious crimes, organized crime, such as infiltration, telephone tapping, surveillance measures. This is missing for now, and very often practitioners tell us that actually environmental crime is organized crime. The eco-mafia is organized crime. Therefore, we need to employ the same methods which we use to combat organized crime, also in the area of environmental crime. And last but not least, indeed, our agencies, Europol and Eurojust, need to be part of this. They need to be informed. They need to be connected better with the networks of practitioners. We have a network of environmental prosecutors in Europe called NP, and we talk to them, including today, by the way. I had a meeting with them this morning. They need to be better connected and tuned into the international cooperation channels so that Europol and Eurojust are informed about possible cases and they proactively support these investigations. So this is what I wanted to say. Ecocide is a difficult matter. Obviously, we are very interested in the explanations that we have received from Professors Camproux and Jaworski. I can tell you that more than 20 years ago, I have tried in the context of the Council of Europe to introduce autonomous offenses which are equivalent to ecocide to some extent. This convention has failed, and I know that Madame Jaworski is working on improving it, but it's mainly a failure because it contained this autonomous offense. Member states are afraid of this. They need clarity, they need precision. So this is on which we have to improve the directive in the European Union. Thank you very much.
No, thanks to you. Thanks to you. I think that we are so used to a law that is anthropocentric and has been so for centuries. We're used as well to these non-autonomous offenses since a decret, a piece of legislation from Napoleon in France in 1810, which was then spread throughout the world. And before it wasn't the case. So it's really also a French legacy, which is quite bad, that is blocking for centuries the move towards autonomous crimes and ecocide. So I'm sorry for the non-French people, because that's mainly our responsibility. Yeah, I believe this is really important. We are touching upon the end. I propose that for some, can we say again 5 or 10 minutes? But just to point out also for those who will have to leave now, that there are some questions and answers in the chat. I think it's mostly from NGOs used to climate litigation, actually, and raising the questions and raising the issue of due diligence and environmental crimes. And that's one of the weaknesses of the text from the European Parliament, actually, that we didn't ensure that criminal responsibility would still be working in cases of due diligence in the proposal from the committee, from the Parliament. But we'll have time to work on that in the coming years or weeks. But also there was an issue about climate and due diligence, and maybe a last issue, but why don't we have, and that's a bit also what we called in the report from the Parliament adopted 2 weeks ago. Thanks, Madame Pérignon, merci beaucoup. She left us, but one of the issues is about liability, and this time civil liability, well, also penal, but also civil liability on CO2 emissions. So on the report adopted 2 weeks ago, we are asking for a liability for diffuse pollution, among which CO2, and also the obligation for the companies to respect the Paris Agreement. This is also what we saw with Shell in the Netherlands last week. But yeah, this would be also leads to follow. But I know that we have those questions. Maybe we can take the coming minutes for each one of you to say goodbye, and when we answer them in the meantime in a very short way. But what I want to do, because they are the ones who wrote the studies, worked for so long. So I'd like to first to give the word to Marie-Pierre, maybe to begin with, because I saw that your mic is open, but maybe to give us a feedback on what you heard, and also how you want to move forward with your proposals, and do you want to keep on working with us, and how should we do that? And if we also all of us still here, can help you in any ways. So Marie-Pierre. But you closed your mic in the meantime. Le micro est fermé, juste pour précision. Il était ouvert il y a 3 minutes.
It turned off mic. It was on earlier. There we go. I'll hurry, because I know we're focusing more on criminal code, but it also affects the civil code. So there was a question which I quite liked in the chat, and Isabelle Pérignon responded about the directive regarding national due diligence, because I actually would have quite liked to know how this coincides with the reform bill for the environmental liability directive. Can we combine the two? Can we combine the reparations of environmental damage into that? What are the points in common? When we talk about reparation for environmental damage, what I find interesting is that every time you can add to it a new aspect of liability or responsibility. So there's different due diligence in different countries. And so you should be able to add or complement to this the idea that when harm is caused to the environment, things can be added. So that is not the case at the moment, but I think that would be interesting. That's why on this reform of the directive, they're also talking about environmental responsibility. So I'll be following that very closely. I think it's very interesting. There's a lot to be done, a lot of progress to be made. This directive has really got the ball rolling, but now we need to go further. We need to take this further in terms of definitions.
Passer de la police administrative.
And as I was saying earlier, we need to go to the administrative police. That's not enough. So we need to look at civil liability as well. And that's what they had wanted at the very beginning with the directive. So this is the direction that we need to work in. Then there are lots of very important smaller aspects for this civil liability to be effective. I will now give the floor maybe to Véronique. If there are other questions, I'm more than happy to answer them, but I'll give the others their turn. Okay, so just a few words on the issue of criminality. I'm very pleased to see that one of the priorities for the European Commission is environmental crime, and that is the same for the European Parliament. I think that over the next few months, one of the challenges that we're going to face is having a legally binding text regarding autonomous offences that can go beyond administrative barriers. We need to look at sectorial offences and administrative offences, but we need to go further and add another dimension to this European criminal code regarding the environment. So autonomous offences, just to clarify, in a European context, still talking about Europe here, within the Council of Europe, they are carrying out deep reflections on environmental protection through the criminal code. So an ad hoc group of experts was created in January of this year. They have already had several meetings, and they are carrying out discussions in the same vein. They are talking about the recognition of autonomous offences, having a systemic approach that goes further than the text that we currently have. So I do think that the winds of hope are blowing. They are coming from Europe, because I don't think we should only focus on a national level. I do think there is hope here, but we need to try and translate this hope into reality. Thank you very much, Véronique. There's a question talking about how member states might block this barriers, these problems. Mr. Daoud, just a final word. Yep, very quickly, just to react to what Madame Marie-Pierre Camproux mentioned on the civil aspect and the need for this due diligence directive. Yes, we need to carry out this due diligence, but I want to draw your attention to the fact that we need to do this at a European level, but in France already, there are some points of references that have been edited by commissioners looking at how companies can carry out due diligence when external growth occurs. So when you are a lawyer and you want to question the civil liability companies and how which methodology they should use, then you need to carry out due diligence in terms of environmental aspects. Now, I'm not saying that this is a panacea, but this is something that already exists. Now, I also want to add, I don't know about the equivalent legal system. I don't know if this is very widespread in Europe, but we have made considerable progress in environmental and climate protection through the jurisprudence of the Court of Cassations in France, who ruled less than 3 months ago that the criminal responsibility of companies that have merged, that responsibility doesn't disappear because of this merger. Before, it was deemed that the company that merged and then disappears through the mergers, then their actions disappeared as well. But this is not the case anymore. So this will encourage companies that are doing the takeover to really strengthen their due diligence before they move on to merging or acquiring a company. So this isn't only about financial law, banking law, but environmental law will also be taken into account here. I spoke earlier about how I am a happy fool, but again, earlier we were talking about the winds of hope, but there is also winds of hope coming from judges who are taking the initiative, who are also being optimistic about this affair. But we need to be measured in our approach, I think. Thank you, Mr. Daoud. Can I just add to this metaphor about the winds of hope? Environmental damage was recognized by the Court of Appeals in Liège last week. They wanted indemnities for environmental damage. So that's also, you know, headed in the same direction. There are also statements in directives that should be applied as they are. And I thought the directive was going to be a lot more direct than what member states are doing. But I think maybe this is a question of interpretation. It'll be in the treaty. The treaty gives a certain degree of maneuver to member states when it comes to transposing directives. With regulations, it's different. But with directives, there's a lot of room for maneuver when they are transposed into national laws. So maybe we should ask for an ecocide regulation rather. We can't hear you, sorry. Unfortunately, when it comes to criminal code, we can't do regulations. We can only do directives. Jojo.
Words before we leave.
Hi, thank you. I think probably I'd just leave with perhaps a little note of hope around the clarity issue that Peter brought up, very much anticipating that when this definition concludes, that this panel that we've convened is working on, which will happen in the next couple of weeks, and we're due to launch it on the 22nd, and very much hoping that that will help in that particular area, and also inspire the project at the European Law Institute as well. Thanks so much for everyone.
Okay, and then Mrs. Smirnova, and then maybe we can close this brilliant conference.
Thank you very much. I have nothing more to add than just again express my gratitude for being part of this very interesting discussion today. And I wish good luck to the authors of this study with promoting the results of this study. Thank you.
Well, thank you. We will keep on doing so. Peter, I didn't, but do you want also a last word since we're raising questions?
Well, if I have a right to a last word,
okay.
Like a condamné à mort, my last word is that I have started with Madame Delmas-Marty 30 years ago, discussions about the European Public Prosecutor's Office. It has become operational yesterday. It took us 30 years, but we got there. So never lose hope. Thank you.
Thank you. I hope it's going to be quicker though, but yeah. Thanks a lot. Merci beaucoup spécifiquement à Madame.
Thank you very much specifically to Marie-Pierre and Véronique for sharing your study with us. We will continue these discussions and continue promoting your study and your proposals. Thank you to each and every one of you, because I know that you have also been doing this work for months. Thank you to interpreters,